A subpoena for your therapy records can feel like someone rummaging through your private diary with a clipboard and suspicious confidence. If you are dealing with an accident injury claim, do not ignore it, hand over everything, or panic like the courtroom just turned into a reality show. First, send the subpoena to your accident injury lawyer right away. Your lawyer can check whether it was properly issued, whether the request is too broad, and whether the records are actually relevant to the case. Therapy and counseling records often have strong privacy protections, but privilege rules vary by state and by the type of record involved. That means the answer is not simply "they asked, so they get it," and it is also not always "nothing can ever be shared." A third party might subpoena records from your therapist, counselor, clinic, or insurance company instead of asking you directly. Your lawyer can contact the record holder, object to the subpoena, or ask the court to cancel it or narrow it. One common problem is a request for every mental health record you have ever created, from the age of dinosaurs to Tuesday morning. Your lawyer may argue that the request should be limited to records connected to the claimed injury, the treatment period, or a specific issue placed into question. You should not casually sign a release that covers your entire medical and counseling history. A broad release can open doors that have no business opening, including the mental equivalent of your junk drawer. Sometimes the opposing side argues that your mental health is part of the lawsuit because you claim emotional distress, anxiety, sleep problems, or trauma. Your lawyer can explain how making a claim may affect privilege and whether a narrower claim could protect more of your private information. The rules can also change when records involve substance use treatment, minors, domestic violence services, or specially protected counseling programs. Those records may have extra safeguards, so your lawyer should review the exact request instead of guessing from a search engine headline. If a subpoena arrives, preserve it and any related notices, but do not call the opposing lawyer to explain your personal history. Let your lawyer handle the conversation, because one nervous sentence can grow legs and sprint into a legal filing. Your attorney might file a motion to quash, seek a protective order, negotiate limits, or ask the judge to review records privately. A private judicial review is sometimes called an in-camera review, which sounds fancy but usually means the judge looks first before anyone else gets a peek. The court may limit who can see the records, require redactions, restrict copying, or order the records destroyed after the case. These protections are not magic invisibility cloaks, but they can reduce unnecessary exposure. Be honest with your lawyer about counseling, prior symptoms, and what you have claimed in the case. Surprises are fun in birthday parties, not when the other side suddenly produces a record you forgot existed. Your lawyer may also separate treatment records from billing records, appointment dates, diagnosis codes, and notes. Even when some information must be disclosed, that does not automatically mean every private detail gets an all-access pass. You do not have to understand every procedural rule to protect your privacy, but you do need to act quickly. Read the deadline, forward the documents, avoid deleting anything, and ask what your lawyer plans to challenge or limit. If you want to learn more about our company, check out our links in the description.